Hello.
Morning everyone.
Morning.
Welcome to ABTOT and Travlaw's fourth joint Zoominar. We are focusing on Brexit today, but that does not exclude any other sort of pressing travel matters. So please ensure that you use this opportunity, as with previous occasions, to send through any burning questions or concerns you have, generally or business specific. And our expert panel will try and provide some up-to-date guidance and assistance for you. We have Matt, Nick and Natalie from Travlaw today. In a moment I will hand over to Matt to go through the basic housekeeping. Those of you that have joined us before will be fairly au fait with this now, and in fact we're all Zoom experts 6 months down the line. Who'd have thought it? We will be looking at the results of the ABTOT Brexit survey at the end of the advice and guidance from Travlaw, so that's something to look forward to. It's been an interesting read. Thank you for those that have taken the time to send that back to us. I know some have had some connection issues, so you may not have been able to send your comments through. There is still time. We've had a good response so far, but the survey is still open. So if you wish to get those comments added in, please do so. I will hand over to Matt now, and look forward to an exciting and helpful session as ever.
Thank you, Samantha, and good morning, everybody. And thank you for laying me up there with a "this will be exciting" promise. It's Brexit. Exciting, not sure that's the right word, but thank you everyone for coming. Good morning. Indeed, the focus today is going to be on Brexit, but what we always say is, these are opportunities for you to ask questions about anything that's on your mind. Do try and test us as usual. We will do our best, and anything that really stumps us or that we have to take offline, our promises, we will try and find you an answer as part of this seminar. For those of you that don't know myself, Nick and Natalie, we are from Travlaw. We are a law firm that deals only in travel and leisure law. So in theory, exactly what you do. So again, we like to think we know what we're talking about, but you be the judge. Quick housekeeping rules, because we've got quite a lot to get to, I think, today. Standard Zoom stuff, as Samantha says. We're not expecting it to be a huge group today because there's a lot going on. So, by all means, have your video on. If you think the bandwidth can take it, then let's do it. If you can keep yourselves muted just to avoid the usual stuff, the postman, the diggers outside, the dogs attacking the door when the postman arrives, that would be excellent. At the end, we will do some questions. I think the easiest thing to do with questions is always to put them in the chat. Type them in the chat. Bear in mind that if you type in the chat to everyone will see your question. You may not mind. If it is a private question that you want to be asked on a no names basis, but for the benefit of everyone, please select either myself or Samantha or Nick or Natalie, and we will have that question asked and give the answer without referencing you. It is really Brexit and COVID as well. If you are thinking it, I guarantee someone else is thinking it as well. So do please ask the questions. Right, without further ado then, allow me to share my screen and we will start looking at Brexit. The biggest thing we haven't talked about this year by a million miles. What we're going to do is, this is meant to be, because there's so many issues with Brexit, and Brexit is not all things to all people, it has to be said. We've found that some travel businesses don't really care about Brexit at all, and that's the wrong approach to take. Some travel businesses don't care about Brexit so much, and that's okay for them because of the way their business is structured and what they're doing. I think everyone should at least have a passing interest in it because it is such a significant event. However, this session is meant to be more of a things you should be thinking about if you are not thinking about them already type session. So what I'm going to do is I'm going to hand over to Nick in a minute. He's going to take us through a few points. It's more a tick list, more a prompt for you to think, okay, I've already thought about that. I've covered it off. I know what I'm doing. That's fine. Or, never even thought of that. Or that's a good point. Maybe we should look into that a little bit more. We're going to focus to a certain extent on the whole issue of employees working abroad, etc., because we found that that is a particularly important issue no matter what. Natalie's going to cover that off in a little bit more detail. Then we'll transfer on to Samantha, who's going to go through the Brexit survey results, which are fascinating, and well done to ABTOT for raising this again and for getting input. And then we'll take the questions. So we'll aim to finish for 11 o'clock. As always, if it pushes over 11 o'clock, we will stay to answer any lingering questions, but we do appreciate you've probably carved out this hour, and at 11 o'clock, we will all, if you want to leave then, of course, that's fine. We know you've got other things to be doing. So preparing for Brexit generally. Nick, why don't you take us through the first set of points?
Yeah, thank you, Matt. So as Matt said, I'm going to try my best just to keep this to a very simple overview, and I've got 4 points to do just that on. There's one of these 4 points I will dwell on a bit more detail, and that's the financial protection, because I do anticipate that's one of the areas of it's causing a bit more confusion than others, and I think there's a bit more interest in. So I'll quickly rattle through the other 3, if the PowerPoint can stay still.
All right, my fault.
So no problem. So the first point is really just thinking about all your contracts, whether you've got contracts with your customers, suppliers, agency agreements, I'm sure employees as well, potentially. I'm not sure if that's something Natalie will cover, but any contracts you've got with any party, just to think about what's in them. There may be explicit references to European law, and some things may be cosmetic, but some things may be there only because you were obliged to do certain things under European law. It may well be that on exit day, very little has to be done, because most of European laws is going to be retained and enshrined in UK law. But some things are no longer compatible, and it's something to think about just generally going forward, because it's not just about exit day. There's going to be a review process over weeks, months, and years after we leave the single market. And, you know, without trying to excite anyone, people are talking about, you know, will package travel regulations be diluted after the whole fiasco with, you know, pandemic refunds and so on. So these are just things to be aware of, that, you know, keep your ears close to the ground and be aware, follow any news stories, and if you think anything that might be up for the chop when the UK are reviewing any European laws, then it's important to, you know, look at your terms, because you may be offering terms that you don't need to, and unnecessarily constraining yourself with obligations and offering things to customers, for example, that you don't have to. So that's really just something to think about with all your contracts, and just be aware of. So I'll skip financial protection for now and just quickly just talk about litigation. So the third point on the list, if you are either potentially looking at claims to make maybe debt recovery from a supplier, there is an important cut-off date for this 1st of January exit day. So it's something us lawyers talk about a lot in terms of various European laws, which we've never explained to our clients because it's not necessary, but things to do with which law applies, which country can you bring the proceedings in, how cost effective it is to do the proceedings, because of, you know, how do you deliver proceedings to a French supplier, for example. So due to the EU having this harmonized approach, there's all sorts of regulations and directives, which makes this a really sort of streamlined and more efficient process. And so the key point really here is that all that falls away on exit day, so that if you have issued a claim before the 1st of January next year, that's fine, all the same rules apply. So if you bring in a claim, you may think, I'll try and get that in court and stamped by the court before exit day, because things will be to some extent easier, maybe cheaper in terms of your legal fees. On the other side of the coin, if you're trying to back people off, you're trying to keep people at arm's length, you may want to keep that going until after exit day, because you may find that the person pursuing you for money may have more hoops to jump through and to try and pursue you in their home country. So again, just something to think about with any potential claims you've got for or against, and this deadline coming up. And the 4th point, really quickly here, it's I'm sure something everyone's aware of. It's information to your customers, basically. And I think the government give really good advice on this, actually. It's very concise, it's online, they update it regularly. So I think the key point is just to be, you know, aware of where to find it on the government website, and make sure it always mirrors the information that you're giving to your customers. The last thing you want to be doing is having on your website or in your booking confirmation emails or T&Cs anywhere, you know, where you say that you don't need this or you don't need that, or you do need this, and then it turns out that, you know, the rules have changed and the government have, you know, made progress with what is and will not be required, you know, after we leave the single market. So just something to be aware of, but very useful government website information. So my final point, which I mentioned, that I anticipate may be wrong, maybe one for people to ask questions on later, is about financial protection. So the expression people may have heard of is the mutual recognition of financial protection across Europe. So if I briefly explain what that means, it's in a sense, it's a bit like a passport for your insolvency protection. So if you've got ATOL protection or any other ABTOT bonding, however your bonding scheme would work as a UK tour operator, that is, if it's recognised by the UK law, you can essentially take that all over Europe to market your services in France, Germany, Slovenia, all over the European market. So if you literally have no interest in marketing in Europe, never have, never will, this is probably something that's not going to concern you. If you are doing that on the other extreme, where you are marketing all over Europe and maybe you're not interested in the UK market at all, this is going to be a much bigger concern. And equally in the middle, there may be people who have very targeted markets, you know, people who may target specifically France, or specifically France and Germany, who will certainly also be concerned about this. So the key point is that whereas right now you can take your UK financial protection and market your services all over Europe, after we leave the single market, that's no longer possible. Or certainly it won't be possible automatically unless the government comes to some sort of deal, either on a EU-wide basis or with individual countries. You will find yourself either A, having to set up an office in Europe to give you full access to the market, which is what you would be thinking if you were dealing with lots of countries. If, however, you were dealing with one or maybe one or two countries, you would be thinking to speak to, say, a French lawyer and say, what do I need to get, you know, insolvency protection to markets in France? And then that probably leads on to other things like accountants and, you know, insolvency providers. So obviously there's some cost involved there, but those are the two obvious options if the government do not solve this problem. And other than that, so, well, I think that's the headlines, like I say. So if people do have questions on this, if people are concerned, definitely something to ask questions about later, and I can help people as much as I can do. So I think that's my 4 points covered, and as much detail as I need to for now, and I'll move on to Matt.
Thank you. Thanks, Nick. Yeah, as Nick says, it is not all things to all people, as I say, all these points. Some people are very concerned about that point. Some people are less concerned. Obviously, financial protection as an ABTOT member comes from a fairly obvious place. So, you know, do speak to ABTOT if you've got any concerns. But I don't know if we're hopeful, if we're expecting that there will be some news on this at some point that will allow you to continue to trade with Europe if you want to, as Nick says, under the existing arrangements. We shall see. This is the problem with Brexit, that everybody wants answers at this point, and there are so few to give around. And it isn't because they're there and we don't know about them, it's just because we're still waiting to hear what the various decisions and agreements and what the government does and what's agreed with Europe comes out. Anyway, one of the things that, again, is talked about a lot, we get a lot of questions about, is the issue of what about people? I have people working for my business in France, maybe they're working in chalets, you know, wherever really. And that is almost certainly going to change, as Natalie will now explain.
Thank you, Matt. Morning, everyone. Yeah, as Matt was saying, many of your businesses may host UK workers abroad for ski holidays, or you might have tour guides or tour reps. So my talk's going to focus on the effect of Brexit on the posting of workers to the EU. And the reason why the Posted Workers Directive is important is because any worker who is posted temporarily to the EU for up to 18 months will be caught under this directive. And before I go on to what will change after the transition period, I'll just set out very briefly what the current position is. So at the moment, the Posted Workers Directive, which is an EU directive, of course, gives workers who are posted temporarily to an EU member state the same floor of employment rights as national workers. So what that means is that they get the same minimum rights as workers in the country that they're working in. And that includes things like working conditions, so maximum work periods, minimum rest periods. It includes pay, so minimum paid annual holidays and minimum rates of pay. And it includes equality of treatment between men and women. And the whole purpose of this directive was to avoid local terms and conditions of employment being undermined by the use of cheaper foreign workers, and to avoid the abuse of foreign workers receiving less beneficial terms and conditions of employment. So this directive will still apply until the end of the transition period. Next slide, please, Matt. So the position after Brexit, it's not so clear at the minute because it depends on what is negotiated between now and exit day. However, what we do know is that the free movement of labour will end. And after this, if there isn't any alternative agreement, then UK employers who are sending staff to the EU after Brexit will have to make sure they're meeting the conditions in each EU member state and comply with the local laws there. So the Posted Workers Directive will no longer apply to the UK unless you establish a business in an EU state and hire staff locally, or where you already have a UK national who's legally residing in an EU member state and you post them to another EU member state. So they're the only conditions where the Posted Workers Directive will still apply to the UK. So ultimately, the result of the Posted Workers Directive falling away means that it will be up to each member state to decide what rights UK workers have in their country. Next slide, please. So in terms of practical considerations, the first step is that you'll need to seek local specialist foreign lawyer with regards to what the employment are in that country, because the rules may differ between each member state with regards to things like holiday pay, minimum levels of pay, and rights on termination, because some member states do offer quite generous termination packages. With regards to the right to work, you'll have to ensure that your UK workers have a right to work in the member state that they're currently situated in. So if you've currently got a worker who is posted in the EU who is staying there after the 31st of December, you need to make sure that they're complying with the relevant laws. Most EU states will probably require UK workers to apply for a residence permit, and the deadline to do that is by the 30th of June next year. For any workers who are posted after the 31st of December, it's likely they'll need a visa and work permit, and as their employer, you may need to help them obtain those documents. So tax implications are something to consider, because depending on the rules of the host country, employees might be charged income tax in multiple jurisdictions. And where that is the case, the UK has what's called double tax treaties with other jurisdictions, which means that only one country has a right to tax the income. If both countries have a right to tax, then the employee can claim relief from double taxation. The position with regards to national insurance contributions after exit day is currently unclear, so we need to monitor the position and see what's agreed. But currently, the Posted Workers Directive allows employers to keep UK workers who are in the EU under the UK national insurance contributions regime, which means that they're exempt from the host state social security contributions. And in the absence of any alternative agreement after exit day, it will be necessary to make more expensive local deductions instead. So how can your business plan for the future? Well, if you haven't already, it's best to start planning now, because if we do leave without a deal, businesses are going to have little time to prepare. So it would be a good idea to carry out a Brexit impact assessment, where you undertake a review of how your workforce is going to be affected. So, for example, to what extent do you rely on UK staff working in the EU? Identify how many staff you have. Review the current contracts. Are any of them coming to an end soon after the exit day? Or do you need to review your future contracts to make sure that you are complying with the local terms and conditions? As I mentioned earlier, one option to prepare for the worst case scenario is to establish a business in an EU country, recruit from that country, and then rely on the Posted Workers Directive that way. The downside of that is that that will require more administrative work because someone will have to manage that business, but that is an option. And lastly, it goes without saying, keep up to date with developments, because a lot of what I've mentioned does depend on what is actually negotiated between now and the end of the year. So just make sure you are aware of visa and immigration rules, tax implications, and local employment law. When it comes to getting local employment advice, we have a network of international lawyers, so if you need help getting in contact with the right person, we can assist you there. Thank you, Matt.
Thank you, Natalie. It is very much a big unknown. And again, one of these issues that for some businesses, they don't have anyone abroad, it's fine. But I know so many of you do employ people abroad. So you need to be up to date on this and having a plan and conducting the assessments that Natalie's talked about. So again, anything that you haven't already looked at that you want some help with, we're certainly happy to have a chat. Okay, moving swiftly on. Last slide from us with just some more things to think about, which I will cover off. Everybody, you know, it's just one scarring event after the other, isn't it? And we all thought that GDPR was bad, and how we wish we could go back to those halcyon days where all we had to worry about was GDPR and what to do with all those sheets of paper locked away in the basement. Nevertheless, GDPR and data is still going to be an issue after 1st of January. The rules are unlikely to change, I should say. You're still likely to have to do all the same things. We are expecting to have an adequacy finding from the EU that will basically allow data to transfer between the UK and the EU member states, as we have been doing. It seems unlikely that that's not going to happen, but right now it's not absolutely nailed down, so watch this space. But just to say, that's probably not going to change. Tax, you know, in the forms of VAT and Tom's VAT in particular, again, not something we really advise on because it is an accountancy issue. But remember, people forget Tom's VAT is a European instrument. So not being a member state, there is a prospect that this will no longer apply. That seems to be the current position. However, far from wanting to be a doom monger, don't expect there to be nothing in its place. It's not just going to disappear and you won't have to pay that tax. Something else is going to be there because Her Majesty's government is not going to give up that kind of revenue if they see it being there. So, but I don't know for sure. The advice here is you should all have good accountants, and you should all have good accountants who know travel. And we found that that is particularly important. And I know that there's some affiliate members that ABTOT have that they can point you in the direction of should you need any expert advice on any of those issues. And they are all good businesses as well. As I mentioned earlier, for those of you that were on the call at the very start, the interbus agreement and the lack of any developments on is an issue if you do coach trips. If you do not do coach trips, unlikely to be an issue for you. But again, you need to be aware about what the lay of the land is here. Right now, unless the UK gets a move on and signs up as a separate entity to the interbus agreement, coach trips to the mainland of Europe are unlikely to be possible. It's that simple. So again, we assume that it will happen, but it should have happened by now. And it's just another one of these points that's been caught up, I think, in the political game of football that is going on. And again, some people don't care about foreign exchange. Some people tell me their entire business relies upon foreign exchange rates. I can't say too much about that because no one knows what's going to happen. But again, you just need, if that's not a risk for you, you don't need to worry about it. If it is a risk point for you, you need to have a plan there. What are you going to do depending upon what happens with foreign exchange? And last but not least, one of the things that always surprises us at Travlaw is that people spend years creating a good brand, a really good reputation. That's what you trade on, that's what you push out to customers, that's what you have within the trade. And then we see so many people not taking steps to protect one of their main assets. So trademarking is a thing, it's a very important tool for you to use. And there are three basic levels of trademark: a trademark covering the UK only, a trademark covering Europe, and a trademark covering the world. These things exist. So if you haven't looked at that yet, please do so. The reason we mention it now is that if you have a European level trademark that protects your brand, your trademark brands across Europe, that's still going to carry on until the expiry of that trademark. There's no point applying for one now because, quite frankly, it wouldn't come back to you in time anyway. But it is something to think about going forward. You will now have to do a slightly different process to get a European level trademark, but it certainly is possible. So there we go. They are the main headline points. If anyone thinks we've missed anything out, and I don't think we have, but feel free to shout, put something in the chat, and we'll cover that off. But those are all the various things. I'm hoping that having gone through all that for the last kind of 25 minutes or so, you will all say, yeah, we've got all that done. We've got it all ticked off. We've looked at all of that. Great. In which case, it's not time wasted at all because you will feel better that you've done that. If there is anything there that you're not sure about, you still have time to look at it. It may be something you can talk to us about. It may be something to talk to ABTOT about. It may be something to talk to someone else about. As I say, one of the ABTOT partners, like accountants, etc., Elman Wall, you name them. They're all there. So thank you very much for that. We are going to move on now. I'm going to pass back to Samantha to go over the fascinating, it has to be said, early results of the Brexit poll that ABTOT have been doing. And this is a nice early insight for you guys, actually. So something to look forward to. But do think about questions while Samantha goes through that, and then we will come back, answer off anything that you might have as best we can. Thank you.
Thanks, Matt, Nick and Natalie. That was a very helpful summary. As I think they've made patently clear, the repercussions of a simple yes/no question 3 years ago are far from simple. They're wide-reaching, there's a lot to think about, and there's a number of issues to start working your way through if this does in fact affect you. Now, I know as my role in membership that it is affecting a number of members, some more than others. We've lost one member who is looking to move their business to an EU state so that they can continue operating. It's sad, but it's an understandable decision whilst the uncertainty continues. We've also lost another member who has simply decided that it's too difficult to continue operating as the last British operator in France and in their particular sector, added to the COVID impact that they've had. They've simply decided to draw a line under their business this year. Not unexpected, but no less upsetting anyhow. So moving on to the survey, thank you again for those that have been able to send their response through. We've had 55 responses. There were 5 questions submitted. It was a quick 2-minute survey just as a barometer of where our membership felt Brexit was ranking in their top 10 to do things. The first slide covers the confidence in a travel or pro-travel Brexit deal. Those numbers pretty much speak for themselves. There's an overwhelming 78% of those that replied who do not feel confident that the government is going to have travel up front and centre in their Brexit negotiations. There was a number of reasons provided in the comments with this. Some were citing the lack of confidence they've had in the government's handling of the COVID crisis to date in putting travel up front and centre. They don't feel that's going to be translated into their Brexit negotiations either. I think a lot of the uncertainty is due to the fact that a lot of members who replied don't feel we're going to get any kind of agreed deal. And it would certainly be sensible at this stage, at this late stage in the day, for members to be preparing for a no-deal Brexit. Obviously, the COVID crisis has taken over a lot of the last 6 months. You have to have some sympathy to the resource that the government has had and has had to divert into attempting to deal with that crisis, and it has certainly had a knock-on effect, we have no doubt, in the ability to plan effectively for the rapidly approaching end of transition date. So plan for the worst, hope for the best, I think is sensible advice at this time. But certainly 78% of those who replied don't have any confidence that travel is going to be the main focus of any Brexit deal. We can have the next slide, please. The next question was whether a no-deal Brexit is going to harm your business. And again, these numbers speak for themselves. Over 70% again, nearly 3/4 of ABTOT members feel that it will have an impact. And there were numerous reasons cited for this. There was impact on foreign exchange, there was impact on consumer confidence, there was increased administration and bureaucracy, there was additional hurdles being put in place. All of these are valid reasons as to why your travel business may well be adversely affected by a no-deal Brexit. And those numbers are very worrying. The next slide deals with whether or not Brexit ought to have possibly been put on hold again because of the coronavirus pandemic. Again, there's a large majority here that feels it should have been. For those members that replied no, a lot of the reasons behind that was that there's been so many delays already, and it's almost a case of swallowing the medicine and getting on with it and seeing what's going to happen. There was also an element of Brexit's going to be small fish in comparison to the nightmare 6 months that the coronavirus has inflicted on the travel industry. But there is still a large percentage, 2/3 of the membership, that felt an additional delay by the government in Brexit would have been helpful and would have been supportive. But at this time, there's certainly no indication that that is going to happen, unfortunately, and we are still on course for an exit date of 31st December this year. The next slide is more hopeful, and again, it suggests that preparation is underway, albeit with the limited amount of information that we have on how to prepare. It's roughly 1/3 feel that they are prepared, 1/3 feel that they're not prepared, and 1/3 simply just don't know. Those that feel they're not prepared, and presumably a large percentage of those that don't know, is down to the lack of specific answers at the moment that is in the industry and in the arena. We can only plan up to the point of the amount of information that we have, and without answers to will the plane still be flying, will there be continued mutuality, will my ABTOT bonds still be recognised in France. There is a limited amount of work that can be done, but there is preparation that is underway. As Travlaw have helpfully summarised this morning, there are steps that you can be taking to prepare, and certainly our ABTOT associates such as Travlaw and our accountancy experts can help you with a lot of those issues that have been highlighted. I will apologise in advance for this one. I felt it fair to reflect, that the exact words that we're getting from our members with that top point. This was an open forum for members to put their feelings out there. You can see from the top point that there is a great deal of frustration. There is a great deal of lack of confidence and lack of trust in our government. I think that has been exacerbated by the handling that many feel has been mishandled over the coronavirus as well. There's a significant amount of the ABTOT membership who clearly feel that Brexit in any form is a bad idea for travellers, for themselves, for the economy, for the UK as a whole, and some of those thoughts are reflected in this slide. But for balance, there have been some positives, and the final slide has some of those positives. If you can move forward. Again, some of this I think is just resignation that we are where we are, and we probably just need to get on with it and then try and rebuild. Brexit just needs to happen. That is a succinct summary, I think, of where we might be at. The referendum is done. The campaigning to get it redone has not succeeded. The transition period is coming to an end, and we need to have some clarity and some decision making to take us into the next steps. But these, the feedback we've had so far and your barometer has been very helpful. I hope that this summary again gives those in attendance today some comfort on how they feel their colleagues in this sort of specialist travel industry are feeling. ABTOT is here for questions. Again, at the moment we don't have any more answers than have been suggested to date. We continue to liaise with these. We continue to make our preparations for a no deal or a hard deal or a soft Brexit. But until we actually get those decisions nailed down, we are as much of being in the dark as our members are, unfortunately. So thank you for that feedback. We're going to move to some Q&A. I can see the chat is still quite quiet. So I don't know if we have covered everything that you wished to cover, and therefore there's no specific questions. But if you do have some, now is your opportunity.
I've got a couple of questions that have come in directly, so we can certainly talk about those. But again, this is a good opportunity to get questions in. One of the questions that's come in is to do with the whole issue of posting people abroad or getting people to work abroad. So this is one for you, Natalie. And the gist of the question is, are there any good starting points or tips if I, in previous years, have had UK staff coming to do a season in a chalet in France? So whatever that is, you know, jobs wise, and there's various different kinds of tasks. So if a travel business hasn't looked at that yet, what are the things that they should be doing?
Okay, good question. You should probably look at your current recruitment procedure and who that currently targets. You might need to consider amending that to make sure you are appealing to a wider set of workers. Another thing you probably want to think about as well is the qualifications that person holds. So for example, if you've got someone who's a ski guide and they hold qualification to do that, at the minute there's a mutual recognition with the EU, but we don't know what's going to happen after exit day. So we don't know if those certificates will be mutually recognised in the EU. So that's something to also check. But yeah, the starting point is probably recruitment. Have a look at your current contracts for your posted workers, see if they need reviewing. And then lastly, consider whether or not they need any training or certificates and whether or not they will be recognised in the host state.
Okay, I know that does affect a lot of people, so thank you. Another question that's come in is all about the issue of flying to Europe. Now this has raised its head again recently because previously the position was that a deal had been done to ensure that the last time you know, we were about to crash out of Europe with no deal before the whole thing was extended and we had the transitionary period, there was a point where technically, come that point, there would be no legal basis for flights to travel to and from the EU from the UK, or indeed to fly over, UK airspace if they were going to the EU from somewhere else, which of course is ridiculous. And basically a way forward was found. Now, yesterday at the ABTA Travel Convention, the Right Honourable Secretary of State for Transport Grant Shapps basically confirmed that we're back to that point. So this is a long way of asking the question that's come through privately, but the question is, what is the position with regards to flights? Because if there is no legal ability to perform flights from 1st of January, what the hell are we going to do? Something else that was mentioned by Mr. Shapps was that this doesn't affect rail, and it doesn't affect seagoing transport either, so ferries, etc., etc. And presumably by rail, that must mean Eurostar. There seems to be some kind of deal done there to allow that to happen. But flights, we're an island. Everybody knows this. So that is a big issue. So my understanding is, and Nick, I know you and I have talked about this a lot down the years, and we thought this was an issue that had gone away. My understanding is that we're back to that point where technically there is no legal ability to operate flights. However, there's clearly work going on in the background on this, and it makes no sense to anybody for there to be no way. I mean, it doesn't make sense for the UK, and it doesn't make sense for the EU to have no flights. But we know that there's been discussions going on with pilots to make sure that they can, because again, UK pilots fly for various European airlines and vice versa. So the whole porting of the ability to fly around and do what pilots need to be able to do in terms of dotting around various locations to do their jobs has been talked about. And it just seems incredulous that we could get to a position where all flights are grounded. And I don't think that's going to happen. But that's the position as I see it. Nick, anything to add to that?
No, not at all. I mean, like you say, it just wouldn't make any sense for anyone. I mean, there's a lot of countries that are not in Europe right now that have pretty good access to the European aviation market. So I think it's just in everyone's interest that there's an amicable solution that will be found, and it'll all be. And yeah, it's just not something that I see as being famous last words. I can't see it turning into so much chaos, but it may be an issue for the airlines themselves in terms of what they have to do to, get any licensing in place, or if it's any more costs involved to have that access to the market. But yeah, nothing I can do other than speculate, really.
No, and this is the thing, in that there is such little information, even at this late stage, to be able to give firm answers on it. And it frustrates you, we know, and it frustrates us as well, because we're asked these questions and we want to be able to give firm, solid answers, but there just isn't enough on so many subjects. A lot of them there is, but this is one of the ones where there is absolutely no firm answer. But I can't believe that we will get to that stage. When you look at it, all the flights are there. I know we're running reduced schedules and whatnot, and airlines are having troubles, and we don't necessarily feel massively sorry for them because of everything that's gone on, but they're having issues as well. But flight schedules are planned. They're not looking to stop that. So it seems that the likelihood is that business will be as usual, but nobody can absolutely guarantee that.
One thing to add on that is obviously how you report those passengers may well be impacted by whatever form of deal and arrangements are in place. Now, currently under your ATOL and certainly under the ABTOT franchise, this also applies, but any travel organiser with an ATOL currently declares an Italian couple on their ATOL certificates in exactly the same way that they would a British couple. That may well change depending on the detail that is agreed in due course. But the good news is, of course, those passengers will then fall to be protected by your ABTOT bond. We currently provide the flight inclusive passengers who fall outside of ATOL as part of your bonding anyway. You will potentially see the need for those numbers to be reported under your ABTOT protected turnover going forward rather than your ATOL protected turnover. But the mechanism is certainly in place for ABTOT to re-pick up all of those European passengers in the way that we formerly used to, as well as your international ones, should that apply.
Yeah, it's just a crazy thing, but there's all the whole issue with flights is there are so many different boxes to tick. You know, we're still part of the, I forget what it's called, but I think the European Aviation Safety Agency, and that's going to stop, which seems nuts. But again, that's Brexit in a nutshell, isn't it? That we're leaving all these organisations, which rightly or wrongly, and we know we've had issues with, you know, is it a straight banana, is it a curved banana? Do we really want to give up weights and measures, all this kind of stuff? But we need the government and the EU to agree on exactly how these things are going to go on. So all you can do is keep on watching for the announcements that will be coming out. Obviously, they're going to go like wildfire around the travel industry when they do. So that's as much as I think we can say on that question. Nick, you've said that there's a question coming to you privately as well.
I have had a couple of questions, but I do just have one afterthought on the last point, actually, Matt, which might be reassuring, is that I recall that there's actually contingency planning measures from the EU that are in place. These were actually in place for stage 1 of Brexit when we left the EU, if we left with no deal. And I'm pretty sure that the same things are going to be in place if we leave the single market on the same basic sort of crash out, no deal scenario. And basically the EU had offered unilaterally to say, as a contingency, there are certain, I can't remember the exact detail in terms of months, but for so many months, aviation will continue as normal, trains, etc., etc. But purely on the expectation that the UK reciprocated, you know, basically to stop any mad chaos in terms of flights and so on. So I think that's likely that that's going to be in place as a safety net for exit day. So that's something that we should allay any panic and concern. But yeah, I did have a couple of questions on the financial protection issues. So first question, a good question, which is, you know, basically, so what, you know, what if what are the consequences if someone were to sell packages in France, Germany, etc., without insolvency protection? So from a practical point of view, number one, under, say, French law, the customers would be able to walk away from the contracts whenever they want. So, you know, if you've got holiday booked in 9 months, yeah, they can just cancel, no cancellation charges would apply, because that contract is just not binding unless you have that insolvency protection in place. So that's obviously a risk that customers just walk away and leave you having paid out to suppliers, etc. And the second point is that probably it's a criminal offence. That's certainly the case under UK law, should, for example, a French company sell packages into the UK. Under UK law, it's not a custodial sentence, it's a fine, and there's no limit on that fine. So exactly what the consequences are under, say, France, Germany, you'd have to speak to a French or German lawyer, but if our rules are anything to go from as a benchmark, you're probably looking at a criminal offence and a fine. How exactly that happens in practice, I have no idea, and what the incentives are, but certainly not something anyone wants to be getting involved in. And the second question is a very, very good question, and it's probably the number one question on this subject, I think, which is in terms of, well, I guess reading out the question, what if I don't actively market? So what's the situation, and what's the line between actively marketing and maybe passive marketing? So it's absolutely perfectly fine to, if someone just happens to stumble on your website and books a holiday, and you've got absolutely nothing in your mind as a business where you are marketing towards the European market, just because the customer happens to be French or German or Italian, that's not a problem. Your insolvency protection should apply because you have sold that package in the UK for all intents and purposes. They're taking the complete other extreme. You know, your website is in English and French. You have terms and conditions in French. When you pick up the phone, the customer representatives happen to speak French. All of your flights depart from France. You go to French-speaking destinations in Canada or somewhere. Your brochures and itinerary sort of have got some sort of details or pictures that would suggest it's geared towards the French market. The website has phone numbers in France. So, I could go on and on, but there's basically a list of factors that the courts will look at to decide whether or not they think it is in your mind to market to their country. And the more of those boxes you tick, the currency, do you accept money in euros? Do you insist on euros? All these things, the more of those boxes you tick, the more likely it is that the courts of France or Germany would say, come on, you're obviously marketing this in Germany. People aren't just happening to stumble on your website. This is your objective and this is what's in your mind. And on that basis, that's when you would fall foul. And your insolvency protection would not apply. And that's when you get into all that bother. So hopefully that answers that question, and it is hopefully helpful to anyone who was wondering and maybe concerned unnecessarily if they thought, what happens if a Swedish person just happens to stumble on my website? So that's the only two questions I've got. Okay,
just to explore that a little bit more. Obviously, the financial protection that the business would currently have is important. Samantha, where is it looking in terms of ABTOT? If that scenario that Nick's described comes to pass, whereby you have a member and they're only really selling to the UK market, but it just so happens that someone from Germany finds their way to that website, makes a booking. How does that all stand in 2021?
Well, the ABTOT bond currently protects any customer, irrespective of their location or nationality, provided they are part of the members' projections and they are declared to ABTOT as part of the quarterly declarations. Currently, within the EU, we have recognition by the likes of ATOL France and the other sort of regulatory bodies within the member states that the ABTOT bond is an appropriate and adequate form of financial protection for their residents. ABTOT is, and T&G, obviously our bonding provider, are Brexit proofing themselves as much as they can at this time. Our risk carrier has set up an establishment in an EU state. Our underwriter has made steps, has taken steps to set themselves up in an EU state as well, so that in the event that loss of mutual recognition is lost permanently and no deal is able to be arranged, then ABTOT as an entity can look to see how we can continue to offer that EU-wide protection. But the bond itself has always been able to protect any nationality of booking as part of the protection that we have in place.
So there you go, everybody. A good reason as any to be with ABTOT, because they're thinking forward and preparing for anything. So fair dues. Question from Virginia on the general chat. Thank you, Virginia. I mean, Samantha, I think you can have a view on this as well. But the question is, with the crisis this year, are you seeing less companies offering packages, so regulated packages, as it leaves them so exposed, or the opposite, in fact? I think this is one of these questions that you could ask 10 different people and get 10 slightly different answers, because I think it depends on who you've spoken to and what you've seen. Nick and Natalie, you might take a different view to me, slightly embarrassing if you do, but I will go out on a limb and say, I don't think I've seen massive shifts either way. I think the travel businesses that we've spoken to are comfortable in what they do. What's happened, particularly with regards to the package travel regulations and the whole issue on refunds, et cetera, has been a problem, without a doubt. But I've spoken to, or I've heard of a few people who said, no, we're going to ditch that and just changed completely to agency. So a few of those, but no massive shifts. But any particular thoughts on that from the rest of the panelette?
I'd concur with that. We've seen a few specific members who have sought to redesign their business model, either moving to accommodation only, but still wanting to offer ABTOT protection because they see value in that in terms of consumer confidence, but it does give them more options in the event of a further pandemic lockdown in terms of customer refunds. And again, we've seen a number of limited members who are looking or have actively taken steps to move from an organiser to an agency model in order to be able to trade outside of the PTRs. There's no doubt that travel organisers have felt got at by every party in recent times, whereas they feel ultimately exposed and have seen single element suppliers not have the same burden or the same onerous conditions that they are obligated to follow under the PTRs. So it hasn't been widespread, but it's certainly been something that a number of members and a number of organisers have considered and may still be considering.
Yeah, I'm not aware of any clients who've done that yet. However, what I have had are clients coming to us asking whether or not they are actually selling packages, because this situation has thrown up question marks over that, because they originally thought they weren't selling packages, but actually when we've reviewed the entire situation, it might be that they are selling packages, and then they might want to think about what they do going forwards. But at present, I don't think any of my clients have sold less package holidays as a result of this.
Yeah.
Well, I was just going to say exactly the same as Natalie there, except the other side of the coin, which is with the crisis, people have been, like Natalie said, scrutinising the terms and conditions. But I've been speaking to people who, it turns out, they've been offering packages when they didn't need to, and they just didn't care. They didn't seem to be aware. But with such a spotlight on what you do and have to, what your obligations are to customers, actually when you look into it, sometimes maybe it's things like tourist services or educational service, things that are not necessarily a travel service, and people have just been using the word package liberally on their website, not really thinking about it. So on closer examination of going forward, they've not actually changed the business model as such, and not intentionally. It's just that they've accidentally been offering obligations they never needed to. So similar, but kind of the other side of the coin as what Natalie just said.
Certainly, we've seen a lot of businesses going through a down period, and to put it bluntly, with business owners and directors and managers with more time on their hand because you're not doing the good stuff that you want to be doing necessarily. So as well as the many other things that the businesses have been doing to try and kind of cut costs and review their business and see if they can be more efficient, that is one of them. Just a very fundamental review of what you're doing, and is there any advantage that you're not taking, taking up legally, but it might be, as Nick says, that you're doing something you don't necessarily need to. So definitely worth looking at all of that. Okay, we're nearly at 11 o'clock. I think we've got two questions potentially to look at. One that's come to me, and I think Nick, you've said you've got another one that's coming. Do you want to do yours first?
Yeah, thanks, Matt. Mine's just a bit of a clarification question on what I mentioned before. Possibly I've scared people if I've used the word criminal offence. So the question is, forgetting the EU market, if you sell a package in the UK without insolvency protection, is that a criminal offence? And so I'm guessing this is a theoretical question because everyone here has probably got ABTOT bonding or ATOL. So but the answer is yes. If you sell a package in the UK to UK customers and it's not got insolvency protection, it's an offence. But just to emphasise, it's not a custodial sentence. The offence is a fine. I don't think there's any limit on that anymore. There did used to be. So obviously, if that is a concern to anyone, that is one of the reasons why you should absolutely look at what your services you're providing, and if you think that you're in some sort of grey area as to whether you're selling packages or not, that's where we are. That's where we're here to help to advise, make sure you are not exposing yourself to any of these risks.
Yeah, it does happen. So if you are aware of anyone you think doing that, or you have a concern about your own business, do speak to us in confidence and we can help you out. But as Nick says, it is one of those things that does come with a sanction, but nothing to necessarily worry about going to jail over. But there we go. Okay, good question. And the last question then, unless anyone's got any more pressing ones, and as I say, we'll stay as long as we need to, but it is 11 o'clock now, so I appreciate people have got other appointments and things to be getting on with. The question that's come in is, how likely are mainland EU going to be to refuse coach travel? And the suggestion being, it will lose millions in revenue for the EU in terms of travel for coach operations, etc., etc. Even if the coach traveller has got all their ducks in a row in terms of the contractual side of things. So I think this is coming back to the interbus agreement. And again, seems ridiculous, but in theory, as of 1st of January, coach tour operations to Europe are going to be limited at best, unless the UK signs up to the interbus agreement. It's an odd area of travel, is this, in the sense that, with the EU, we always had the interbus issues, despite the free movement of goods and people, these core pillars of the EU. And it comes down to this amazing thing, of cabotage and, freight and good restrictions to try and level playing fields all over. The best way I can explain cabotage, if you don't know what it is you may have, for instance, a logistics, a trucking company that has a job to take a load of plastic goods or anything like that from, let's say, Berlin to Edinburgh. So they come on their truck, they cross over the border into the UK via Eurostar or whatever, or on a ferry, drive up to Edinburgh, get rid of the plastic goods, drop them off at the warehouse, and then they've got an empty truck. Now, what they could do in the olden days was pick up a lot of stuff from Edinburgh and take it to Manchester, then pick up some stuff from Manchester and take it to Birmingham, then pick up some stuff from Birmingham and take it to London, and then head back out to the European mainland. And this happened in reverse as well, with UK companies doing the same in Europe. So this intra kind of like small jobs in between is called cabotage. And that was basically banned on the basis that it was undermining local companies by people. And, the suggestion was that these trucks coming from the EU into the UK in particular were basically just big moving fuel tanks, and they could fill up on cheap fuel from the EU and do jobs within the UK, having come on under the pretense of doing one job, a lot cheaper, because they could make this fuel last a long time doing all these runs. And coach travel got caught up in that as well. So again, there needed to be this regime in place that would allow coach tours to kind of operate within the EU and within the UK and whatnot as well. And without that happening, and right now we're looking at a situation where coach tours either can't happen at all, or there is a closed door policy where you can't stop until you get to the destination. So yes, you can load up with people in Manchester, say, and take them to northern Italy, to the lakes, beautiful. But you can't stop in between, literally, no toilet breaks, no nothing. And that's not going to work for one reason or another. And the only thing that needs to happen is that there is this extra EU agreement called the Interbus Agreement, which the European Union signed up to, and therefore the UK signed up to. And it goes outside of Europe. It covers kind of like, Eastern European states that are not part of the EU, etc., etc. But the UK was a member by default of being a part of the EU. Now they're not going to be. All the UK needs to do is to sign up separately, and we're golden. However, it's not happening. The UK said they're going to. So it's not a case of the EU stopping us from doing it. And as the person who asked the question, I'll say direct to you, that's not the problem. It's not that they don't want the business and that they don't want it to happen. It's the UK not signing up to the relevant legislation to allow this to happen. And again, like with the air question, it seems entirely unlikely that that's not going to happen, but we're all looking at our watches and we're getting closer to 31st of December and nothing yet. So watch this space, and we Travlaw will be getting as much information out there on this and all the other points we've talked about as and when we hear about them, and can get it into a format to make it useful to you. The travel industry public who want it so much, so keep an eye on our website. If you want to be added onto our mailing list, if you're not already, drop any one of us a line and we can do that. And again, ABTOT as well does a very good job in keeping its members informed of all these issues. So you're onto a good thing there.
Thanks, Matt. Yeah, we're certainly keeping the dialogue going with both the CAA in terms of flight inclusive content and with BAYS in terms of non-flight inclusive content. any guidance that we're able to share, we do. We've got good social media channels. We've got quite a good resource bank on our website, on the blog there, with numerous articles from Travlaw as they keep the guidance coming through, and we'll keep this circle of information flowing. We just need some updates to get that information out to you.
But I think that is probably no more questions that I can see, so I think that is probably it for the day.
Well, thank you everyone for finding the time in your busy weeks to join us today. Thank you to Matt, Nick and Natalie for your up-to-date guidance and advice as ever. We hope you found today helpful. It has been recorded, so we will ensure that the link is shared with anyone that was hoping to join today and didn't. I've got a few messages in my inbox about that, and if anyone who is on the call today would benefit from having this to look back at in the future, then please just drop me an email, and have a great rest of week, everyone.
Thank you, everyone. Stay safe.
Yep, thank you.
Thank you.